Thank you all for attending, making this almost standing room only. We meet again. As our voice from above said, I'm David Horrigan, e-discovery counsel and legal content director at Relativity. And what I do is help our team of many people put together these legal programs. And the law of e-discovery has been good to us this year. I used to think nothing could ever be better than Tom Brady destroying his mobile phone so we could have Deflategate. Well, the e-discovery gods have done us one better. We have Taylor Swift. And today we are going to tell you what Taylor Swift, a burning funeral home, and a hyperlink can do to your e-discovery practice. It really has been an eventful year, not just in the world of e-discovery law, but also in the world of relativity. When I first came on board at Relativity, they made me a promise they have kept, and that is that as part of our legal education program, we have church and state. We don't do sales pitches up here. We're giving you a service. To thank you for everything you do for us, we bring these great legal minds together so that you can get out of the office, come to Relativity Fest, and find out what's going on in the law and in the practice. But I tweeted about this morning. I am really excited about our active learning development here at Relativity, if for no other reason than I will never, ever have to steer the conversation with Judge Peck away from continuous active learning because we have no such product. Soon we will. Thank you, Judge Peck. Thank you back there. It's really pretty huge. You're not here to hear me talk today. You are here to have some of the greatest legal minds in e-discovery talk to you about how the law is developing. We are not going to have one of our friends here this year. Relativity Fest is a little bit later this year. The Honorable David Waxy is enjoying an adult beverage somewhere in a Hawaiian shirt. We wish him well. And we'll, of course, have Judge Waxy back. But the international aspect of e-discovery has now come to the Judicial panel. We are more than honored to have a justice from the Supreme Court of Victoria in Australia with us today. I'm going to tell you all about the judges, even though you know many of them very well. Please welcome the 2017 Relativity Fest Judicial panel. And the first lesson they teach you in law school is lawyers never sit down before all the judges are seated. Our first jurist is someone that you know well if you've been to Relativity Fest before. The Honorable Nora Barry Fischer is United States District Judge for the Western District of Pennsylvania, based in Pittsburgh. She is a trendsetter and a trailblazer in the world of the law, most notably women in the legal profession. She was the first female partner in her firm. She was one of the first female lawyers at her firm. In addition to that, as I've told you in years past, something near and dear to my heart, we are both former legal editors. She's also been very active in mediation programs. Please give a warm Relativity Fest welcome to the Honorable Nora Barry Fischer.
Thank you. Thank you.
I've said it before, and I'll say it again. Our next jurist is the grand poobah of technology-assisted review. If you're at an e-discovery conference, you've probably heard of DeSilva Moore, and you've probably heard of the Honorable Andrew Peck. He is United States Magistrate Judge for the Southern District of New York. He's been there since 1995, and he was Chief Magistrate Judge for a period as well. As you know, he authored the groundbreaking 2012 opinion in DeSilva Moore. Since then, he has added to the jurisprudence of technology-assisted review and in e-discovery in general. Please welcome the Honorable Andrew Peck. Another jurist you know very well, the Honorable Xavier Rodriguez, United States District Judge for the Western District of Texas. He's based in San Antonio, where he is in charge of building the new courthouse in San Antonio. And I am always very grateful that in addition to having a full docket, building a courthouse, he makes time to come and share what he does. I'm also very honored to be a guest lecturer for his class at St. Mary's Law School. And while we're talking about law schools, I would be remiss if I didn't recognize all the academic partner program led by our own Janice Holman. They do great work in the colleges and universities across the country. We've got Professor Bill Hamilton from the University of Florida. I think his students are with us as well. We have Dean Wendy Collins-Purdue, the Dean of the University of Richmond School of Law. Education's been a big deal. Judge Rodriguez has been a leader in this. Please welcome the Honorable Xavier Rodriguez. And then finally, we're mixing it up with some international perspective this year. We are honored to have Justice Peter Vickery, who has traveled halfway across the world to be here with us. He is Justice of the Supreme Court of Victoria, part of Australia. He is well known to the technology-assisted review community for his McDonald Constructors decision, where Australia has joined the nations of TAR, including the United States, the United Kingdom, and Ireland. Justice Vickery has also been involved in a practice directive that is very important for technology-assisted review, something that we could use here in the States. Please give a warm American welcome to Justice Peter Vickery. So here is what we are going to get through in the next hour. You'll be thinking you're in law school. We're going to start with spoliation of evidence. That's where Taylor Swift comes into play. We're going to move on to proportionality and metadata. There is a case that was a decision issued by the Texas Supreme Court that brings up the question. We're now in the era of proportionality. Is the era of getting metadata over? Going on to the Internet of Things. If you thought Taylor Swift gave you some e-discovery entertainment, these cases do more. The fact patterns are so bizarre. I just want you to know that none of us take tragic circumstances lightly. Sadly, both these cases involved someone dying. And so if we make light of a truly ridiculous fact pattern, please know that we mean no disrespect. Going on to technology-assisted review, we will have the American and the Australian talk about how TAR is developing. And then we end with the attorney-client privilege. And we are going to take you on a roadmap. How many people remember the game of life? Remember when you had the little tokens you went around the board? We have recreated the game of life to show you how you can waive the attorney-client privilege and maybe how you can avoid it. First topic up, Taylor Swift. How many in the audience have heard of the Taylor Swift incident in Denver? We've got a big group, but not everyone. So very quickly in this case, what happened is that Ms. Swift alleged that a Denver DJ, Mr. Mueller, was inappropriate in his touching of her at a photo shoot. The photo of the alleged incident is all over the internet. You can find it. Why are we talking about Taylor Swift and some DJ here? Because there is an e-discovery angle. So the DJ goes home and he's like, man, I bet Taylor and her people are going to cause me some problems at work for that alleged stupid thing I just did. So he goes and meets with his bosses and he surreptitiously records the conversations. Da-da-da, and it is electronically stored information. In this case, clearly Taylor's people, when they filed litigation, or actually Mr. Mueller sued Ms. Swift for contractual interference. Basically, she got him fired from his job. Taylor Swift people want these tape recordings. I should say audio recordings, not tape recordings. We are in 2017, even if I said 19 earlier. The crux of this issue, and when I wrote about this in the Relativity blog, I called it the classic e-discovery case of the dog ate my homework. Coffee gets spilled on a Macintosh computer, the MacBook. But wait, there's an external hard drive, no problem. That too miraculously disappears and is destroyed. Judge Fischer, first of all, before we get to the e-discovery, the general facts in this case, if you'd been presented with something, Mr. Mueller's actions, what would your response be?
Well, you know, it's interesting to look at this case because this case, in some ways, is the reverse of some of the cases that we see. And obviously, my jurisdiction is just a microcosm of the entire federal system. But we do see a lot of sexual harassment cases, some with very egregious fact patterns. And in this particular instance, if you will, we had Mr. Mueller bringing suit against Taylor Swift, and then she turning around and countersuing. And you don't often see that. I don't know about Judge Peck or Judge Rodriguez, but we don't often see that kind of scenario. I have to say, relative to this case, and as David mentioned, the picture is now out there on the internet, and it's a little difficult to see exactly what was going on. So the case, as everyone knows, ultimately did try. And relative to it, I have to say, I had something akin to this not that long ago, and that case has subsequently settled, where a person who was the Register of Wills in one of our local common pleas court did a lot of the same and then some as we saw with Mr. Mueller. He would make jokes, he would make statements. For example, one of his statements was, I have 13 women working for me. You all need fans because there are 300 personalities in this room, given all the hot flashing that goes on.
Oh my.
And he was also quick to use his hands on people's shoulders, backs, and the like. Here you had, if you will, a furtive tap on the derriere. And so to that end, this case is in effect a one instance situation. And as I said, it was striking to me that Ms. Swift, would bring the counterclaim and then ultimately prevail. The other thing that's interesting about the case, and we were talking briefly about this last night, the decision on spoliation actually comes in two phases in this litigation. Once at the summary judgment stage and then once later at the motion limine stage. But very early on, both sides in a joint motion tried to keep a lot of the summary judgment proceedings away from the public, arguing that Ms. Swift had a lot of fame herself. The judge ultimately ruled that, no, this is a public proceeding, you have a right to know. And to that end, the only thing that he initially kept from the public was the picture, which now we know is all over the internet.
Compliments of TMZ.
Exactly.
Justice Vickery.
How would we handle this in Australia?
Yes.
We would send the coffee spiller to jail.
Are you serious?
Yes.
Jail for spoliation. You heard it here first.
We love our coffee in Australia. But we take a very dim view of people who spill coffee, particularly with the object and purpose of spoiling evidence or defacing evidence or removing evidence. We have in our Crimes Act in Victoria, we were the first in Australia to introduce this section, a provision which runs roughly like this. A person who knows that a document or thing of any kind is or is reasonably likely to be required in evidence in a legal proceeding, whether criminal or civil, destroys it, conceals it, or renders it unreadable, is guilty of an offence. And 5 years is the maximum, or a very large fine. So
5 years in the slammer.
yeah.
Fear
It was introduced,
fills the room.
I might say, as a result of a rather tragic case which was heard earlier. That was the case of McCabe against British American Tobacco. Mrs. McCabe was a smoker. She suffered lung cancer and eventually died from lung cancer. She sued British American Tobacco for her injury. British American Tobacco had adopted what they described as a document retention policy.
We've never heard of that before.
A document retention policy in this case was anything but a retention policy. It was a facility, in fact, to destroy documents, and which is what they set about doing. The trial judge heard the case at first instance and determined that this had happened. The critical documents had been destroyed to the point where he felt that the defence should not be run. That is, the plaintiff was placed in such a prejudiced position that the plaintiff ought to run the case without a defence. So he struck out the defence. That was appealed, and unfortunately, during the course of the appeal, the lady concerned, Rolla McCabe, died of her injury. But as was, the appeal succeeded, and the defence was reinstated. That caused considerable public concern, such that the legislature took the view that this was a perversion of justice in effect, what had occurred, and passed the legislation in 2006 to introduce the Crimes Act provision. So it had a sad and tragic commencement, but we have the law.
Gotcha. Thank you. Judge Peck, and I'm going to come to you and Judge Rodriguez both on this. The court in Swift was talking about the continuum of fault because we now have the Rule 37E intent to deprive standard. In my mind, an intent to deprive is not unlike being pregnant. Either you are or you are not. But the court here said that sort of like a house-trained puppy, where maybe the puppy is sort of house-trained, maybe house-trained, but now we're going to this continuum of fault, so it's not as rigid as the intent to deprive. You've got some leeway. Do you agree?
I don't know. I mean, one of the things that I found was very interesting in this case is that the judge did it under the old common law standards. There is a footnote saying, yeah, the parties cited 37E once, but nobody relied on it, and therefore I'm not relying on it, which seems somewhat peculiar. I think what the judge was talking about on the continuum is the intent to deprive with circumstantial evidence, as in this case, circumstantial being he destroyed 2 devices or maybe 4, depending on some of the other footnotes, his iPad, his cell phone, etc. But the judge was willing to say, well, bad faith, but not clear enough to be intent to deprive. And that's, probably right even under 37E. You don't have to, even if you find either the 37E1 or 37E standards, E2, you don't have to impose the harshest sanction. The other question which I have for you and Judge Fischer, because I didn't see it in the case, was the judge going to let him use the summary clips that he had, even when he had destroyed the whole recording? It's nowhere in the opinion I read, which
It's not
seems
in the
like
opinion,
a strange
and I don't know. But
result.
yeah, exactly. Judge Rodriguez, you ever been tempted to throw someone in jail for a discovery violation?
It's kind of funny how we're diverging just so far from where Australia is headed. A couple of things on this. One is Mr. Mueller actually kept portions of these audio files. And so what was actually destroyed by this alleged coffee spill was only the remainder that he did not file otherwise and give to his lawyer. And so a number of questions immediately come to mind to me. If I was the lawyer, I'd be asking, why are you only giving me snippets? I'm his lawyer. I'd be, as his lawyer, demanding, where is the entirety of this? And there was a big failure there by the lawyer. The second thing is, once the lawyer became aware of having only unedited portions, he had a duty to instruct Mr. Mueller about the duty to preserve. The litigation was already ongoing, and so that apparently wasn't done. And then I guess the last point I have about this whole intent to deprive, a number of cases out there besides Taylor Swift's case is coming up with very, in my mind, generous interpretations to the spoliator. And I'm starting to walk away thinking, well, what is it going to take now to actually establish an intent to deprive? We already have
Barbecuing the hard drive.
well, I guess if you put it on the grill, maybe. We're seeing a number of cases out there where I think collectively the evidence would be able to establish intent to deprive. Some judges are requiring actual manifestations of that bad faith. And it's the rare case that you get somebody up on the stand. And even when there's a case out of the Northern District of Texas that came out last year, and in the deposition, the gentleman says, I got rid of these emails because basically I didn't want them to come out of this case. I'm paraphrasing, but very close to what he said in the deposition. And the magistrate judge in that case said, no intent to deprive. He later, in his errata sheet, correcting his deposition, gave some equivocations about why he might have got rid of those emails. I mean, what is it going to take now?
You know, but the flip of that are the cases that found an intent to deprive from the sort of negligence or gross negligence that 3072 was meant to eliminate. So,
and so, you know, I guess the walkaway part of this, you know, one, this case really did not do an analysis of 37, but I absolutely agree with Judge Peck that there is a lot of loose work by us as judges and the litigants here. We're relying too much on pre-December 2015 cases. You know, my recommendation to you all is forget the pre-December 2015 cases and let's deal with the language of the amendment as
With all
is.
due respect, Judge, we'd be happy to do that if you judges would stop using the pre-2015 cases.
That's true. Yeah,
what
there's
you
an-
mean we, Kemosabe?
All right.
Yeah.
Touche, it's the old lesson. If you're going to shoot at the judge, you'd better not miss.
With regard to intention, the criminal section that I mentioned has the intentions expressed as follows. You've got to do the act with the intention of preventing it being used in evidence in a legal proceeding.
Similar
So that's
concept.
quite a specific level of intent.
Judge Fischer.
If you allege that the dog ate the computer, I suppose you've got to call the dog.
Yeah.
As I mentioned in my opening remarks, I think it does behoove you to look at all the cases that come out of this particular litigation. But if you look at some of the footnotes, and I made a note to myself, because in the summary judgment opinion, the judge writing there says he was dismayed to learn that contemporaneously created evidence was lost in preventable circumstances. The court was also troubled that it appeared that Mueller had already consulted with an attorney about possible legal action at the time the audio files were lost. And then he goes on to say he was surprised that the lawyers themselves were not diligent in, number one, ascertaining whether this type of evidence or information existed, number two, in securing these audio files, preserving them themselves, and then playing them. And interestingly, earlier this morning, I was working remotely here, and I just finished reading a brief on spoliation in my chambers. And there, in addition to speaking to the current law, i.e. under 37, those lawyers are also making a pretty effective argument about the lawyer's duties. And to that end, talking about lawyer certification of discovery. Every time a lawyer signs off on discovery responses, that lawyer is saying to the court, I have been reasonably diligent in ascertaining that the answers or the responses to requests for production are accurate. And so there, in that particular case, which involves lost text messages, lost cell phones, and lost email by a number of individuals, all of whom were bringing wage claims, the attack, if you will, is two-pronged. And as we were talking about, when you get into these kinds of cases, and I've written on spoliation now at least a half a dozen times, you as the judge have to really do an in-depth factual analysis. And akin to what the justice was saying, you have to take a hard look at who the players are and how credible the players are. It becomes that kind of thing that you actually have to make findings of fact and then determine on the continuum, if you will, who is or isn't telling the truth. So it's also striking in this case that the ultimate opinion comes up very close to trial, because that's when you're at the motion in limine stage, you should have, as a judge, almost all the facts and circumstances that you can ascertain so that you can determine whether there is or isn't the basis for a sanction in a case.
By the way, to give you a little bit of the shorthand here, this is our 4th annual judicial panel, and for the past 3 years, we've done a deep dive into the federal rules. So we're doing a more case-based approach this year. But just to give you a perspective, when Judge Peck made a reference to 37E2 and 2015, when we were going back and forth on that, 2015 is when the latest major revisions on e-discovery to the federal rules of civil procedure took place. For the sanctions in what used to be called the safe harbor in Rule 37, to get the most severe sanctions, and that was Judge Peck's reference to 37E2, you've got to show this intent to deprive. And where the rules also come to play is in our next case. Well, if the next case will come along, there we go. And this case involves State Farm Lloyd's Insurance. And we may want to keep calm because he's Jake from State Farm, but he may not want to give us his metadata. Judge Rodriguez, you're in Texas, although you're a federal jurist in Texas, and this is the Texas Supreme Court, a court on which you formerly served as a justice. In this case, basically what we're seeing here is a litigant saying, you know, we're in the era of proportionality now, and getting metadata flies in the face of proportionality in certain cases. Judge Rodriguez, will the era of proportionality mean the end of the era of metadata?
So this case, we've this year and last year, we've had a number of hail storms go through the state. And so these are a whole part of a huge wave of litigation that we've had in both the federal court and the state courts. And so in this case, a homeowner makes a claim upon State Farm. State Farm comes up and gives an estimate of damages. The homeowner claims that he was offered an undervalued amount and then brings suit. The case ultimately got included in a whole bunch of state multi-district litigation matters, made its way through that morass, made it back to the individual court, and where the metadata comes in is the plaintiffs were saying, hey, we've become aware already that this production that you're willing to give us, which are just static PDFs, is incomplete because we have already seen that there's photographs with captions that indicate, oh, the adjuster missed this piece of damage here, or the adjuster missed this piece of damage to the walls and roofs here. And so by offering this static PDF, they were going to be missing the relevant captions here that would help them make the case that the claims were being undervalued. State Farm had this system where all their claims material, even if it came in first native form, ultimately got processed through a system they called ECS. And then if you want to ask something from the ECS system, it was given to you in a static format. And so State Farm objected to the request for production, saying, we're only going to give you from the ECS data. We are not going to go to any of these other sources where this may arise. Ultimately, the trial judge and the Court of Appeals judge agrees with the plaintiffs that they made a relevant showing, that State Farm failed to object with specificity as to why they were objecting to native production of these other points. Goes up to my old court, the Supreme Court of Texas, and you know you're going to lose when the first sentence says, e-discovery cost a whole bunch of money. I paraphrase, but that basically is the opening sentence there. And otherwise, the Supreme Court, I counted, 55 times they make reference to cost in one form or another. And so, you know, we're all trying to get a handle on the cost of all this. And ultimately, I think that the court might have gotten this right, but they got it right using the whole wrong road to get there. And so my problem with the court's opinion is, it's just like in the federal rules. We look to whether or not the material being requested is relevant and then proportional. And so now, with all due respect, because my good friend here, Craig Ball, was representing the plaintiffs as their discovery expert, I think there was a mess up by both sides here. I think the plaintiffs here failed to make a showing, at least at the Supreme Court, about why was all this relevant. The court got fixated on the cost aspect of all that, and I think that they needed to make a lot clearer demonstration of relevance. And then when it came to proportionality, of course, as part of the proportionality factors, we look at the cost of all this, and I think there the plaintiffs fixated too much on making an argument, this is actually cheaper for State Farm. If they just give us everything in a native, it doesn't cost them to convert anything, it just goes into the systems that we want to use, no excessive cost. And State Farm, I think, argued some generalities about the cost and how much they were going to have to go into these other data points to see what may or may not be relevant. Now, they got a do-over at my old court, and so I go back to what rules, if they still exist. You know, if you were going to object to a request for production, you had to object with specificity. You don't get a do-over, basically here, in light of the new standard of proportionality applying to the forms of production, as well as just even requests for production. The court basically gives them another shot at it. So it'll be curious to see what, if anything, happens in the go-around. But I think the two learning points of this now is courts are really trying to grasp and get a handle on the cost of all that. You know, that's all fine, but it's not going to go away. Everybody in this room knows that electronically stored information is only going to get worse. We've talked about the Internet of Things, how that's going to be an explosion in the growth of information. For those of you who might be interested in cross-border discovery, we're talking about data privacy and the implications of all that. That's going to add an extra burden. I don't think we as courts, you know, although we need to be cognizant of the cost, we need to be cognizant of using technology as a solution rather than attacking it as cost, because that's not going to get us anywhere.
That's a great point. By the way, speaking of Craig Ball, please join us at 4:45 this afternoon, where Craig will be giving his expertise on the Internet of Things. It'll be a great session. Please join us. Justice Vickery.
Yes, we would judge the case as to whether or not metadata should be discovered by reference to whether or not the metadata is likely to be directly relevant to an issue in the case.
But Judge, if I could ask you something else on that, though. Say, for instance, I walk into your court in Melbourne and the metadata is critical to my claim that my stockpile of Vegemite sandwiches has spoiled.
Yes.
And there are allegations of spoliation of the spoiled Vegemite sandwiches, but let's face it, nobody likes Vegemite sandwiches, and so the damages are minuscule. Even if it's completely relevant to the Vegemite sandwiches, are you still going to let him have metadata if it's a small Vegemite case?
I happen to like coffee and Vegemite. So
Oregon is misfiring repeatedly today.
It proves the know your judge before you make an argument.
I don't have Vegemite sandwich cases in my court. It's likely to go to a small claims tribunal where discovery isn't permitted anyway. But taking the issue more generally, we would judge the admissibility of metadata by reference to whether or not the content of the metadata is likely to be directly relevant to an issue.
Right.
Even in a small dollar case.
Well, I don't do small cases, so.
Well, right. Okay. Let's hypothetically. You're forced to sully yourself with these minor matters. Vegemite.
Hypothetically, I would not admit it.
Okay.
In a small case, hypothetically.
Judge Fischer, what do you think?
Well, metadata becomes important given the nature of the case. And so here, as Judge Rodriguez pointed out, the Texas Supreme Court had a lot of maxims there, but I'm not sure that they ultimately came to the right decision. But then again, there are those cases that turn on metadata. I think one of the largest verdicts this past year was a case of about $32 million. And the plaintiff's lawyer there said it turned on a very small piece of metadata. And so where we see metadata being important is where somebody has gone through a document and changed the document, changed the dates, changed critical terms and the like. You know, frankly, having been an insurance defense lawyer and knowing what insurance claim files look like, I don't know how this metadata would have been that critical in this particular loss, you know, of the hailstorm damage, perhaps. But it would have been a stretch, I think, to have persuaded me in that vein.
Okay. Moving on to our next cases, the Internet of Things. Our two cases are State v. Debate and State v. Bates. As I said earlier, they both tragically involved deaths. In State v. Bates, the Arkansas case, it got a lot of play early in the year because prosecutors wanted to access the data that was gathered by the Amazon Echo, known commonly as Alexa, because that is the trigger that you use. You call Alexa and you get information. In this situation, tragically someone died. 3 guys in a hot tub with this bottle of Sky vodka, 2 come out. They said, you know, that they weren't sure what happened here. 2 things involve the Internet of Things here. Number 1, they want the Alexa data. Number 2, there was some highfalutin water meter on this house that was able to track an enormous usage of water in the wee hours of the morning. Prosecutors' theory is that the reason the water consumption went up is because they were washing off, or he, Mr. Bates, was washing off evidence of the crime. As a general matter, from a data privacy standpoint, Judge Peck, shouldn't 3 guys be able to hang out in a hot tub and not have to worry about the Orwellian nightmare of Big Brother prosecutors coming along and interrupting the Sky vodka party?
Well, if all 3 of them come out of the hot tub alive, that's one thing. When one of them doesn't, you know, everything is fair game. Mr. Bates argued at one point that he had a privacy interest in anything he said to the Alexa device, which brought to my mind the arguments that lawyers were making in the early days of social media discovery. Yes, you know, 5 million of my closest friends can see what I post under a privacy regime on Facebook, but it's private and the government shouldn't be able to have it, nor should an opposing litigant. That didn't go anywhere with good reason. Unless one is getting into a Fifth Amendment protection area, there is no privacy defense, particularly in a criminal prosecution. You know, one lesson from this is if you're in a room with an Echo device and something bad is about to happen to you, scream out Alexa and hope everything gets recorded after that. I'm not really sure what the prosecutors thought was going to be on this device because nobody seemed to indicate that the deceased shouted Alexa. But, you know, the real takeaway from this is we've barely gotten a handle on email and text messages and maybe mobile, and now we have to deal with all the Internet of Things type devices. I think the water meter was much cleverer by the prosecution. You know, there was some blood in the hot tub, so the water use, makes sense. In the debate, however you want to pronounce it, case which involved a Fitbit, which is why we have this picture here, Mr. Debate had this story of how somebody broke into the house and killed his wife and tied him up, and eventually he got free, et cetera, et cetera, et cetera. And he had a very detailed timeline of when, during all of that, his wife had died. Unfortunately for him, his wife's Fitbit was still on her and showed her alive and moving around the house after he said this intruder had tied him up and killed the wife, et cetera. So again, it's a case where the Internet of Things had useful information. A more recent case, the name of which escapes me, but was an arson investigation where instead of the classic arson case where you empty the house before you burn it down, the defendant here called the fire department and said, my house is burning. I'm going to just toss a few things out the window, but please get here quickly. And of course, virtually all his contents of any value were sitting on the lawn when the fire department showed up. And he claimed he did all of that in the few seconds between when he called them, etc. He had a pacemaker. And they looked at his pacemaker data and said that if he had, thrown all of this out the window under the stress of the fire licking around him, etc., there would have been much more heart activity in that 2-3 minute interval. And the inference from that was he had indeed put it all on the lawn at his leisure, then set the house on fire, and then called the fire department. Some of these are perhaps far-fetched and more in the criminal area. Certainly cell phone location data, GPS data from one's cell phone is a common occurrence in the criminal sphere. I even think that the U.S. Attorney's Office is overdoing it in that. But in virtually every time I rotate through our criminal duty part, we're getting requests for prospective cell site location information, sometimes to be able to find a fugitive, but other times to do it for 30 days or so and just develop evidence of the drug dealing or whatever the other crime is. And in fact, there is a case, I think the name is Carpenter from the Sixth Circuit, before the Supreme Court this term on what standard the police need to get historical cell site location data. The theory on the government side being the third-party doctrine, which is an old doctrine from bank cases. If you give your banking information to the bank, you don't have any Fifth Amendment rights in it or any expectation of privacy. The argument is by using your cell phone, the cell phone companies collect that information in order to know what cell tower you are near so that they can connect calls if you make one or if you're getting one, and that therefore there is no expectation of privacy, and therefore under the Stored Communications Act, a 1980s or so era statute that is in bad need for many reasons of being updated, they're entitled to get that information without needing probable cause and a warrant.
Judge Fischer, if we were to go back to debate for a second, that image that you see on the screen up there is actually my wrist. And it's one of the rare opportunities I get 10,000 steps, so I got to promote it. But the real story behind that is I am doing some yard work, and I've gone to the gardening place to get a bunch of shrubs. I'm driving a U-Haul truck. Congratulations, you've done 10,000 steps. I'm sitting here in a U-Haul. And that got me thinking it must have been the vibration of the truck doing that. And then, when you come to Relativity Fest, you see all the speakers, and it's an amazing a number of people that go into this conference, whether it's Kelly Lohan, Anna Sarunian, Andrea Sakata, Blair, the whole events team, or the people, when you see all these graphics, I do the rudimentary ones. The real ones are done by our incredible team. Used to be K Agency, but we don't say that anymore. They're the Relativity Agency. It's J.C. Steinbrenner, Nicholas Matijak, Amy King, Sarah Vachelon, Winona Lozado, and Carrie Conway. And the reason I mention them right now is because I'm sitting there at the Relativity offices, and we're talking about the reliability. And they say, oh yeah, all you got to do is fix your hair. And I'm like, Whiskey Tango Foxtrot, huh? Go like this. I'm straightening my hair. You're going to get a lot of Fitbit data. Judge Fischer, reliable?
Well, see, that's the issue. And I think that relative to these items of technology, some of them are going to be challenged by Daubert. And to my mind, some of this equates to the litigation we've had in the past over polygraph and use of polygraphs, whether it is or isn't reliable and the like. So I think you're going to see the same thing here. And those kind of challenges, just as you said, the Fitbit could misread for one reason or another. And by the way, on the Fitbit side and also on the GPS side, relative to Fitbit, there was a case not that long ago in Pennsylvania in state court where Fitbit data on the alleged victim of a rape actually helped prove the defense, because she had complained and charges were brought that she had been raped. Indeed, the Fitbit data said that she was not raped, given the fact that she was doing other things. So ultimately, she was found guilty, sentenced to probation and community service. And relative to GPS, we talk about it a lot vis-a-vis phones, but there are so many other industries where you find it. And hearkening back to my prior life as a commercial litigator, we represented a number of trucking companies, and I'm sure those of you in that area know that every and all trucks are tracked. So you have all kinds of data that's out there available to you, and I would suggest to you that would parallel no matter what field that you're in. And to that end, I often will raise at case management conferences with counsel, well, have you thought about this data? Have you thought about surveillance film? Have you thought about cameras on the outside of the building? Do you permit photographs in the workplace and the like? Those kinds of questions, I think counsel need to be routinely asking of their clients, because this kind of information will ultimately surface.
There's no doubt that data privacy is clearly intertwined with e-discovery, and I'd encourage everyone in the room to make that part of your career. E-discovery, people will go, huh? Data privacy, people get. Corporations get. It's a need. And so I think it's exciting times to be in this industry. Technology-assisted review. When Judge Peck issued De Silva Moore in 2012, it was pretty groundbreaking, I should say. Justice Vickery, when you came down with your decision, did you anticipate there'd be a lot of pushback? What was it like to be a trailblazer in TAR in Australia?
Well, it was very interesting. We're very much at the infancy stage. We've got a lot to learn, and as a result, the legal profession and litigants aren't familiar with the process. By and large, there's a huge range of skill sets. You can get sophisticated firms who are on top of it, but at the other end, you've got the suburban solicitor who isn't, and they can be in the same case. So one of the big factors here is slowly, but also to proceed with assistance through an educative process. And the number of ways we are attempting to do this. One is to set out in a guideline protocol form in our practice notes a checklist of the sorts of things that need to be discussed or considered in developing a TAR protocol, so that someone who's inexperienced in the process can look up the checklist and say, I've got to consider these things. Foreign language documents, non-text documents, what sort of system we should use, what sort of verification we should adopt, how do we attack and deal with privileged documents, all of those things in a kind of checklist form. So that provides a part of an educative system. The other way I've used or developed an educative system is through the appointment of a court-appointed assessor or a special referee, as we call them.
Similar to what we call a special master.
Right.
Yes, and that's proved to be a very important process. And in McConnell-Dowell, I directed that, and it's set out in the judgment why I did that. And part of the role was to facilitate the development of protocols and also to more or less supervise the process and give confidence to parties about the use of TAR, its advantages, but also enable parties to formulate a cost-benefit analysis, knowing what the system is. As we know, TAR involves an investment, quite a significant upfront investment. And to justify that, a litigant who's unfamiliar with the system needs to undertake a cost-benefit, a risk analysis, if you like, and be satisfied that the process will be worth the investment, as it were, just like making any commercial decision. And the other element of it is for the court to maintain, if you like, a a regulatory or monitoring function through reports from the expert assessor or special referee to the court from time to time. So the court is appraised of where the parties are at and can make orders consequentially upon the reports that come in. So it's a monitoring process as well. And we found that that's worked particularly well in the McConnell-Dowell case and another case where I'm managing.
Judge Peck, we're in the early days in TAR in Australia, and I know this is incredibly difficult because they don't end up in reported decisions and we don't know how many people, but if you had to guess, what percentage of cases in the US today do you think use TAR?
Still a small percentage. I think most of the cases I see, parties are still telling me they're using keywords. But what I am glad to see, and it's anecdotal, not statistical, I'm seeing more and more cases in my court where in passing, when we're doing the case management Rule 16 conference or otherwise, the parties just say, oh yeah, we're using TAR. No big deal, no fight, et cetera. And I think the law in the US is at that point where there are still some open legal issues, which we'll probably talk about tomorrow. Chance for you to do your shameless plug.
And now, time for shameless plug number 4,278. Tomorrow, please see the United Nations of TAR, where you'll see Judge Peck, Justice Victory, Karen Hardy of McCann Fitzgerald, who, of course, argued the Irish case approving TAR, and, of course, our old friend Chris Dale of the E-Disclosure Information Project will be representing the United Kingdom. Before we get to today's last case, are there any questions for the judges? Anyone got a question you'd like to ask? Yes, sir.
Speaking about cost of TAR, one of the issues of cost is using search terms prior to using TAR. And some judges have ruled against that, some are okay with that.
The question is, how do the judges feel about using search terms before you use technology-assisted review? Judge Peck.
My view on that has changed somewhat. I mean, in a perfect world with a narrow collection, then I think you should not use keywords first, because obviously anything the keywords miss, whether because of misspelling, synonyms, or whatever, will not be in the corpus that then goes through the TAR process. But for two reasons. One, cost structure is still in many of the vendors where there is a higher cost for the TAR being run, and so getting material out through keywords is an economic necessity. And secondly, if you take a very broad collection, the richness may be much, much lower if you haven't been doing some pre-screening through keywords. So it really will depend on what the collection process has been, and as the cost structure moves, it may be easier to run TAR without keywords. Footnote to all of this, it's perfectly acceptable to use keywords to find key documents. In other words, not in an exclusionary sense, but finding relevant, maybe even hot documents to then use to train the TAR system. That's different and can always be used.
Justice Vickery.
Yes, in McConnell-Dowell, there were a combination of pre-TAR technologies used. One was keywords, and the other was deduplication technology, which you're probably familiar with.
Yep.
That had the effect of reducing the discovery pool from 4 million, or approximately 4 million, to about 1.4 million. So it was a significant step before engaging TAR, and reduced the costs of TAR accordingly. So it was a useful exercise.
Excellent. Judge Rodriguez?
So you raise a very good question, and it actually is a real complicated question, because procedurally, unlike Australia, where the judge apparently has more of an interactive process on how discovery production is ongoing, I start off just with the rules, and we have a real tension between what Rule 1's trying to accomplish and Rule 34, and I find nothing in the rules. I call it the mother may I concept. May I use tar? May I use tar in this fashion? And I know people want a pontifical blessing, right? Yes, my child, this is going to be fine and there will be no trouble anymore by you doing this. But there's nowhere in the rules that I find that that's my role as a judge. My role as a judge is once the production has been made, if there's been a showing of deficiency in the production, then we get involved in a motion to compel or a motion to produce. And then procedurally it gets teed up for me to resolve. But at this stage, the mother may I stage, I don't see where I have a role.
This is one where Judge Rodriguez and I, who usually agree on things, disagree. I think that the December 2015 rules are asking judges to be more hands-on in managing cases. I think the factors in the Rule 16b conference with the court and subsequent conferences give the court the ability, if the issue is teed up in a way that is appropriate for court resolution, to let the parties know what they can and can't do.
Why isn't that an advisory opinion?
Because it's, I think it goes back to just, speedy, and inexpensive. It's expensive enough to do e-discovery. And if you want to know, can I use keywords first before using tar, and the court says, that's your problem, you're getting the big bucks, do what you want and we'll see where things are at the end.
So under that slippery slope, and you're going to involve yourself whether they can use tar or not, even, if you can just keep going down that road.
Well, Sedona Principle 6 says, and I'm a believer in it, that the responding party has the best ability to decide what method it's going to use.
And going down your continued shaky foundation, you could impose
Nothing
upon
like
the party.
a good circuit split among the judges.
Tell me how you really feel, Xavier.
Let me take this to neutral ground. A long, long way away.
Before this ends in a bar fight.
We have in our commercial court, and I run the technology, engineering and construction court as well, a very strong regime of case management where the judge is actively involved in managing cases. And we do this through regular directions hearings where the parties are brought before the court on regular dates. They advise where they're at with the case. Any issues on an interlocutory level are resolved. And it's during those directions hearings that if there is TAR engaged, that's where reports will be delivered and progress will be monitored.
Excellent.
So we take a very active role.
In our last case, we're going to talk about the attorney-client privilege and how not to blow it. I'm about to read a line from a court opinion that will be not unlike fingernails on a chalkboard for Judge Peck. And the line is, quote, "The parties agreed that a formal court order under Federal Rule of Evidence 502D was not necessary based on the scale of the case." Judge Peck, your thought?
Yeah, that's the most ridiculous thing I ever heard of the parties doing. How much time do we have for this?
We are
panel,
running
Heather?
very hot.
Okay.
We're almost out of time.
All right. So basically, and you'll see the third bullet here is the 502D Peck poll, a name that my friend Judge Rodriguez gave to what I often do, and I'm putting my hands up over my eyes so I can actually see past the second row. How many of your organizations regularly, or at least occasionally, use a 502D non-waiver order?
Look at that.
It's mostly the front rows that are saying yes. So those backbenchers, in the interest of time, a 502D order is a non-waiver order. It is, in my view, for anyone who's perhaps not on the plaintiff's side with very few documents, it is malpractice not to get a 502D order, because no matter how careful you are, some privileged document is going to slip through. And 502D provides that a federal court may order that the privilege or protection is not waived by disclosure connected with the litigation pending before the court, in which event the disclosure is also not a waiver in any other federal or state proceeding, even with different parties. It is literally can be done in 2 paragraphs. I have a very simple 2-paragraph 502D non-waiver order up on the Southern District of New York website under my rules. Paragraph 1 says, this is your 502D order. It is, should be interpreted to provide the maximum protection allowed by the rule. And then for those who worry that if they're in front of a judge who doesn't understand all of this, he or she may say, great, you've got your 502D order, press the Staples easy button and produce all your material in 30 days without having time to do a privilege review. So paragraph 2 says, nothing contained herein is intended to or shall serve to limit a party's right to conduct a review of documents, ESI, or information, including metadata, for relevance, responsiveness, and/or segregation of privileged and/or protected information before production.
Needless to say, Judge Peck is not a fan of the lawyers in Earth Solutions.
No.
Our second case here is the Harleysville Funeral Home case. The general story of this case is don't email hyperlinks in a production. Funeral home burns down. Holding is the funeral home, and Harleysville's the insurance company. Harleysville thinking, as they say in Texas, that dog don't hunt. Something's wrong. They think that there's been nefarious activity. So Nationwide is the owner of Harleysville. The insurance companies are all part of a consortium, the National Insurance Crime Bureau. And so they forward surveillance footage in a box account without a password, send it forward. Then a Nationwide employee uploads the entire file. This is that game of life, and you see the game of life has lots of twists and turns. Once again, the file is uploaded, and the link is emailed to Harleysville Counsel. Holdings Counsel issues a subpoena to the Crime Bureau for the claim file. You know where this is going. It gets produced. We're going along, and you can see Holding Funerals Counsel accesses without disclosing that they've got it because they got a hyperlink, unsecured, without a password, forwarded to them. Whoops! And you can see where this is going. It goes both ways on here. I wish we had more time to take you through here, but you can see where this story goes up on the screen in front of you. If you're doing productions, you've got to use proper care. This is the kind of case where you will waive the attorney-client privilege. The court in Harleysville said it was not unlike taking your client's confidential information, putting it on a park bench in the public square for the whole world to view and enjoy, as in this case they did. Our final thoughts, Judge Fischer.
Well, relative to this arena, I think that once again, caution is the word. And no matter whether it's in representing your client and making sure the client has turned over to you all of his or her data, whether it's using this 502 order, and just like Judge Peck on our Western District site, we have a detailed 502 order. Since we've employed it, nobody is opting out of it. They're all using it. Continue to keep up with all the changes and the developments. This Internet of Things, I think, is going to bring a lot of issues to the fore, not only privacy, but compliance, data security, and even First Amendment rights. So there will be a lot to learn as we go forward.
And as we finish our lightning round, 30 seconds from Judge Peck.
One of the lessons of Earth, besides getting a 502D order and not trying to do it more informally, is to document all the decisions and actions you take in discovery. In Earth, the senior lawyer tells the judge, I spoke to the junior associate who, quote, believes, close quote, she did a privilege review. I'm not quite sure how you can not know if you did a privilege review and only believe that maybe you did. But had they documented all the actions they were taking during discovery, they would have been in much better position.
Judge Rodriguez.
I'll go back to that State Farm case. A lot of you are information technologists. Your job is to inform your lawyers about just what's happening with the files. Where are the files? How difficult is it to retrieve the files? So when we start making these proportionality arguments, they can be informed, because unfortunately, I think garbage in, garbage out. If it's not communicated well to the court misunderstands it. We're already at a baseline that we're still trying to achieve an understanding of a lot of these topics. Garbage in, garbage out. Unfortunately, in my opinion, State Farm Lloyd's was garbage out, and I think it could have been remedied.
And the final word from the gentleman from Australia.
Last year I had a case which I call the pot calls the kettle black case. Plaintiff sues a commercial rival for breach of confidential information. In the course of discovery, the plaintiff is inadvertently comes across privileged information provided by the defendant. The plaintiff then knowingly uses that privileged information to replead its statement of claim. That was discovered, came before me. I had no trouble ordering that the pleading be struck out, the whole legal team of the plaintiff be replaced, costs together with delivery up of the offending information. So there are sanctions that the court can and will adopt in inadvertent discovery processes.
Excellent. And now, before I go buy Justice Vickery a coffee and a Vegemite sandwich, I encourage you to join us in a few minutes at 2:15 for the future of pro bono and public service in the legal industry. As you may know, the Trump administration has called for cutting the budget till there's nothing left of LSC. James Sandman, the president of LSC, is going to be joining us. Monica Bay will be there. Right after that, it's e-discovery with the government, with former U.S. Attorney Ronald Sharp. Jason Barrett will be there. Tracy Greer from DOJ will close out the day, as we said, with Craig Ball, and Judge Fischer will be there as well. We're going to be talking about the Internet of Things. Tom O'Connor will be there as well. On behalf of all the developer partners, the partners, and the over 800 Relativity employees across the world, thank you so much. Judges, thank you.
Thank you.